Bruen next week, so I'll be taking mental notes.
Good afternoon, everybody. My name is Ryan Gapsky, and I'm the Speakers Director of the William F. Buckley Jr. Program. It's my pleasure to welcome you all to today's panel discussion on West Virginia, Dobbs, and Bruen. Before we begin the panel, I'd like to say a few words about the Buckley Program. The William F. Buckley Jr. Program is an organization dedicated to promoting intellectual diversity and open political discussion at Yale. Our over 500 Buckley Fellows have a wide range of political views, but they all stand united against the formation of a liberal-only echo chamber on campus. We've hosted a number of lectures, dinner seminars, firing line debates, and annual conference each year since 2011. By providing Yale students with a forum to engage meaningfully with serious conservative thought, the Buckley Program has become an institution on Yale's campus and a symbol for a more open and more representative political atmosphere. Especially at a university where the mission is the cultivation and creation of new knowledge, Buckley Fellows believe that all perspectives must be heard and examined in good faith. If you'd like to learn more about the program and how to become a fellow, visit our website at buckleyprogram.com. Now, it's my great pleasure to introduce our moderator today, Professor E. Donald Elliott. He has been a professor at Yale Law School since 1981 and now teaches part-time as distinguished adjunct faculty at the Antonin Scalia Law School. Elliott has advised 6 presidential campaigns and teaches and writes in fields as diverse as administrative and constitutional law, civil procedure, and energy and environment. He is the author or co-author of over 70 articles and 7 books and writes regularly on popular legal topics for the American Spectator. Elliott also has practical experience as the head of the environmental and product stewardship practice groups at 4 large international law firms. He is an elected member of the American Law Institute and the American College of Environmental Lawyers. Elliott was appointed by President George H.W. Bush and unanimously confirmed by the Senate to serve as Assistant Administrator and General Counsel of the EPA from 1989 to 1991. He was a law clerk to U.S. District Judge Gerard Jezel and D.C. Circuit Chief Judge David L. Bazelon. So without further ado, here's Professor Elliott.
Well, thank you very much for that very kind introduction. Are any of you here in Davenport College? Oh, good. I was a Davenporter, and my fellow Davenporter, George W. Bush, I don't need a microphone? Oh, great. My fellow Davenporter, who was there when I was a student, George W. Bush, when he gave the commencement speech at Yale, said, to those of you who got A's, congratulations. To those of you who got C's, you can become President of the United States. Tonight we are privileged to have 2 people who illustrate what happens to people who get A's. And that is they go on to become distinguished professors and public intellectuals. And we are really privileged to have 2 of the really great conservative thinkers about law with us tonight. I think there's nobody who can match Ilya Shapiro for his commentary on the court. He is the author of numerous books, but perhaps even more significantly, he's filed over 500 amicus briefs in the Supreme Court. He holds a BA degree, an AB degree from Princeton, a master's from the London School of Economics, and a JD from my second favorite law school, which is the University of Chicago, which was the first law school to offer me tenure, Ilya. I don't know if you knew that. They offered me tenure and then Yale matched it. So, he is currently a senior fellow and director of constitutional studies at the Manhattan Institute. And before that, he was executive director and senior lecturer at the Georgetown Center for the Constitution. And before that, a vice president of the Cato Institute. So we all welcome Ilya to Yale, and we're looking forward to his comments. His colleague on the panel, Robert Leider, is a colleague of mine at Scalia Law School, and I'm proud to say he really represents the next generation of conservative intellectuals in law schools, and I'm really expecting great things from him. I've had the opportunity to see some of his work. He also has a distinguished academic record. He graduated summa cum laude from the George Washington University, has a JD from Yale Law School, and a PhD in philosophy from Georgetown University. He is really an expert on the subjects of self-defense, gun control, and the Second Amendment. Both Robert and Ilya have experience in private practice as well as academics, as do I. With that, let's give them a round of applause and welcome them to Yale. So I think the way we're going to do this tonight is each of us will summarize one of the three major Supreme Court cases that are the subject, and then the others will comment and ask questions briefly, and then we'll try to save at least a half an hour for your questions and back and forth at the end of the program. I'm assigned as the environmental lawyer to talk a little bit about the West Virginia versus EPA case. The West Virginia versus EPA case, which enunciated or expanded what's come to be called the Major Questions Doctrine, was the review of a rule promulgated under the Obama administration in 2015 called the Clean Power Plan. And the Clean Power Plan basically would have required the states to change their electrical grids to focus more on renewable energy and less on coal and other fossil fuels. This decision was actually stayed by the Supreme Court in 2016 and never went into effect, and then it was revoked by the Trump administration. That led me to write an article in the American Spectator saying that conservative judges should be true to their arguments about judicial restraint and not rule on the merits of the case, that say the case was moot because the rule had been vacated by the DC Circuit and the current administration said they had no intention of enforcing it. They were going to develop their own rule. But that's not what happened. The Supreme Court, in an opinion by Chief Justice Roberts, held that the Clean Power Plan was beyond EPA's authority. And it could have done that on pretty benign conventional grounds, that the Clean Power Plan was really inconsistent with the language of the statute. I think there were strong reasons to say that was the case. But instead, I think Chief Justice Roberts wrote an opinion that he'd been aching to write for many years, essentially expanding the Major Questions Doctrine, which essentially holds, as it's now been interpreted, that agencies cannot seize on vague language and use it in a creative way. So even if something is arguably within the language of the statute, if it involves a major question of political significance, economic significance, or historical significance, the agency is not permitted to interpret obscure language in a statute to give it broad powers. In that, I think of the case as basically, one of my colleagues at Yale, Bruce Ackerman, has written about what he calls agency forcing statutes, statutes that force agencies to take action through things like citizen suits or deadlines. I think that the Supreme Court's decision is an attempt to have a Congress forcing statute. It's an attempt to actually force Congress to make decisions that it wishes to avoid by making broad delegations to administrative agencies and let them take the flak. The difficulty with it is that Chief Justice Roberts, in his opinion, says it's for, quote, extraordinary cases. And unfortunately, the test that the Supreme Court has come up with so far, based on history, the fact that the agency has not done this very frequently in the past, et cetera, these are not very good tests to limit the power. And as a result, a lot of lower court judges are tempted to find almost anything they don't like as a major question that requires clearer authorization by Congress. The main authority that the Supreme Court cited as a precedent for the major questions analysis in West Virginia versus EPA was a case called Brown and Williamson versus FDA. That was a case a number of years ago where the Food and Drug Administration attempted to regulate cigarettes as an addictive drug. And the court looked at numerous situations where Congress had considered giving them such legislation and had declined to do so. So the FDA seized the bull by the horns and said, well, cigarettes are a drug and it's addictive and it's not proved to be safe and effective, so we're going to regulate it. The Supreme Court said you can't do that. That's the kind of question that is a question for Congress, not a question to be delegated to an administrative agency. What's often forgotten is that Congress immediately amended the law to give the FDA exactly that power. So in a sense, in the precedent, the court was successful in actually forcing the Congress to take a difficult policy decision. Well, there's plenty more to say, and I'm sure we can talk about it, but that's been controversial enough. I think that one of the reasons that Chief Justice Roberts wrote the opinion himself, and as you probably know, when the Chief Justice is in the majority, he gets to assign the opinion, is he wrote an opinion that was fairly moderate and specifically recognized the applicability or the ability of Congress to make broad delegations to administrative agencies. And he said, either where Congress indicates it has this intention or where it is clearly indicated that it intends to make a broad delegation to the agency. And in a different article in the American Spectator, I've argued that that was an attempt by Roberts to limit the damage to the so-called administrative state to so-called exceptional cases. And with that said, I'll turn it over to my colleagues to comment and ask questions.
I think this is the most important case of the term. I mean, the ones that Robert and I are going to be covering on abortion and guns obviously get the attention, but in terms of jurisprudence, in terms of governance, we're going to be talking about this case, not just for EPA regulation, but all aspects of the administrative state, whether it's the FDA or securities or labor regulations, I mean, all over the place. This is the court trying to rebalance separation of powers. You know, Silenter, as Don said, even, Roberts at least, was solicitous of congressional power, but certainly was not saying agencies can take for themselves without very clear, explicit language, awesome power. So Congress, if you want to put in massive controversial policies, whether regards to the Clean Power Plan or anything else, be our guest. But we're not just going to allow agencies to do that, and that's going to be a big rule, especially in the today's the last decade or more, where we have governance from the executive branch by pen and phone and tweet. That's a big deal because it really pushes the ball back in Congress's court.
I think the open question here is how far can Congress go in doing that? And so underneath all this is a doctrine that's known as the Non-Delegation Doctrine, which says, or used to stand for the idea that there was some limit in which Congress could not delegate its power. It can't, for example, Congress could not, for example, say to the Justice Department, go draft a criminal code that is in the public's best interests, and then leave the regulations to the executive branch on how to draft them. And there was an early Supreme Court decision, this was known as the Non-Delegation Doctrine. There's the early Supreme Court case which invalidated an attempted delegation of power pursuant to it. But since then, there has been little or nothing. The court has upheld virtually every delegation since then. And I think this case is significant because it did not reinvigorate the non-delegation doctrine as such, but it did say that if Congress is going to delegate broadly, it had to speak in clear terms. And so I think that's significant for two reasons. One, that it does not on its face yet prohibit broad delegations from Congress. It's just sort of an information-seeking rule that Congress has to be clear when it does that, and it brackets the more difficult issue on which some of the justices have staked positions earlier in their career that would recognize some upper limit on how much delegation can be done. And the second is that you see methodologically textualist judges invoking what are in essence anti-textualist canons and getting some criticism for that. So this opinion did not say that this was outside the fair meaning of the words. What it said is we are going to force Congress to use unmistakably clear language when it tries to delegate this sort of power, and the dissent criticized the majority for not engaging in its, in the linguistic enterprise that the majority justices often do in these situations. But I think in this area and across a range of other topics, originalist and textualist justices are facing questions about what, these are called the substantive canons and the applicability of the substantive canons to these decisions.
Well, thank you. There's plenty more to say, but let's move on. And Ilya, why don't you talk a little bit about Dobbs?
Yeah, well, it's great to be with you. It's great to see so many people out, and it feels odd to say. I'm happy to be at Yale as a Princeton and Chicago man. That seems odd, but nevertheless, at least it's not the law school, right? So you see by my tie, this is my second time speaking to the Buckley program, so I appreciate coming back. And Dawn, by the way, and so to give some assurance to all of you, I did not get A's. I got some A's in law school, but my class, our curve was just blown up. In a class of 200 people, we had 8 Supreme Court clerks, one of whom's already on the Fourth Circuit. Another one was the acting Solicitor General. I had the lowest GPA of anyone who got a circuit clerkship. So what tells you is that in true Chicago law and econ fashion, I was the most efficient. But I was not a straight A student. All right, so Dobbs. There were so many interesting things about this case that have nothing to do with politics. This was the very rare case where everyone's analysis of what was going on changed due to oral argument. That never happens. Oral argument is kind of this theater where it's like tip of the iceberg at best, and all savvy, sophisticated court watchers know it's all in the briefs, and what the oral argument is this kabuki theater where the justices are talking to each other and nothing really changes. But here, going into before oral argument, this is a case where Mississippi passed a law banning abortion with some exceptions after 15 weeks. And we finally have this court that's bulletproof from a conservative perspective, but there are some folks that are more incrementalist. They don't want to go so far so fast. So maybe down the road we can see Roe v. Wade being overturned, but certainly not this early. This is just the second term with Amy Coney Barrett on the bench. I mean, you still have Roberts and Kavanaugh very cautious. No, clearly they're going to have some moderate split the baby, if you will, decision. That was the conventional wisdom. And my own thinking was that they would be cute and overturn Casey, which was the governing standard. You can't have an undue burden on abortion. But what's an undue burden? It used to be whatever gave Justice Kennedy a headache, but he's no longer on the court, so we don't know what it means anymore. So we'll get rid of that, go back to Roe's trimester system, something. That was my cute analysis. At oral argument, very early on, 2 things happened. First, Justice Kavanaugh, the median vote, he's the 5th justice now, not Roberts. Roberts is the 6th man for you NBA fans. So Kavanaugh says right off the bat, why can't we be neutral and just, Constitution is silent, let's get out of this messy stuff. Well, what does that mean? That means overturning Roe v. Wade. That means sending it back to the states. There's no federal constitutional right. That's the middleman. He's saying be neutral, overturn Roe. Huh. And then Roberts proposes his compromise, which everyone was expecting. That compromise being this viability line, that's artificial. That was Harry Blackmun making it up, waving his hands, That's not in the Constitution. You have to have a decent right to abortion. 15 weeks, plenty of time. So let's throw out viability, uphold Mississippi law, and don't even talk about Roe and Casey. No takers for that at all. Not among the justices, not among the advocates. The Solicitor General and the lawyer for Planned Parenthood or the clinics in Mississippi, The Mississippi Solicitor General, they all said, have to go up or down on Roe. Well, based on what we heard, that means Roe's being overturned. That was shocking, right? And then, a few months later, we had the leak, which is shocking as well and continues to have reverberations. We've seen statements at this point from a majority of the justices saying how hard it is and how tense it is and how it affects candor and decision-making and all of that thing. So, when the decision eventually came down nearly 2 months after the leak, another surprise, it was essentially the same opinion that leaked. So even though Alito got both friendly and less friendly advice about his initial draft, he didn't change any of the substance. I mean, he responded to the dissent and Roberts' concurrence, but essentially the same thing. And what did he say? So first of all, he went to what's called the Glucksberg Test. That is, abortion is a claim of an unenumerated right that's not listed, not enumerated in the Bill of Rights. And the court has a 30-year-old test called Glucksberg that says, that asked whether a right is deeply rooted in our nation's history and traditions and fundamental to our system of ordered liberty. And going through a long historical and legal analysis, he said, no, it's not. Moreover, abortion is different than any other type of privacy or kind of other things that might be thrown into unenumerated rights because, unlike, say, drug use, prostitution, marriage, with abortion, at a certain point, wherever that point is, birth, conception, trimesters, quickening, ensoulment, there's a second being with its own rights that clashes with another human being. That's different than all these other consenting adult cases. So that's why, given that this is not a fundamental right according to the Glucksberg test, and it's different, the only thing left to see is whether, for stare decisis grounds, we should still nevertheless maintain Roe. Stare decisis is fancy Latin for let the decision stand, the idea that sometimes overturning an erroneous precedent causes more societal harm than leaving that error in place. And the prototypical examples aren't anything, culture warish. They're securities regulations or corporate governance where lots of institutions are built up around certain rules, and if you, take away that Jenga block, society crumbles. And so Alito went through the now standard analysis. Everyone uses 5 factors, and Alito went back to his what he wrote in a case called Janus, preserving workers' First Amendment rights against union-state collusion a few years ago. That overturned a 40-year-old case. Talked about the nature of the error. Here, Roe was egregious, like Plessy versus Ferguson, so he was not pulling any punches. The quality of the reasoning was poor, not grounded in constitutional text or history. Might have been politically masterful, this compromise with the trimesters and all, but it's not rooted in common law at all. Not workable. Workability is important. It's not applied in a consistent and predictable manner. It has all these effects on other areas of law that distorts, not just our politics and our judicial confirmations, but how we talk about other areas of law. And finally, and probably more importantly than all the rest of it, reliance interests. And unlike those securities or property titles or corporate governance rules, here, you're not planning to have an abortion in 5 years. The only people whose reliance interests are really affected by this decision are those who are contemplating getting an abortion right when this decision comes down. And so not very strong reliance interest, says Alito. So that's it. That's it. It's not a fundamental right. We don't preserve the old erroneous rule based on stare decisis, and so it falls. And I'll leave it there because I think I've taken more than the time allotted for that, and I'm sure there'll be more questions.
Rob?
Yeah, so I think
comments?
Dobbs is a terribly interesting case, and it's interesting substantively and methodologically, and I'm going to start with the latter. Methodologically, you see where the rubber meets the road in terms of different jurisprudential philosophies. So the majority tried to be either originalist or, if not originalist, take a history-based approach. The dissent doesn't even really engage. They kind of acknowledge, you know what, you're right on the history, but we're just going to outwardly take an entirely different constitutional philosophy. And so in prior, in much older terms, the court had some originalists, some conservatives, some liberals, and they were kind of held together by Justice Kennedy's vote. And with Justice Kennedy off the court, that glue is no longer there. And what you're seeing is 2 very different jurisprudential camps that almost can't engage with one another because they're engaged in a fundamentally different enterprise. Substantively, I think this is going to be extremely interesting because it's going to really kind of rock a lot of unstated law that has been assumed to be the case for a while but has never been stated and is very important for reasons beyond abortion. So there are questions, for example, of how far can states regulate people beyond their borders. The Constitution doesn't say what the jurisdiction of the state is. There's just an underlying assumption that it's territorially based. But there are some ways in which states have extraterritorial jurisdiction. So if you have to pay taxes, often you have to pay taxes to your home state regardless of where the income is earned. Or states in very limited cases do criminalize conduct beyond their borders. Well, these things that were once really exceptional are now going to be put to the forefront because I think it's going to be inadequate for a lot of legislatures to say, oh, well, abortion's illegal here, just go across the state line and have it there. And so I think the next front is going to be how far can states go in regulating conduct of their citizens beyond their borders, and what will be the Congress's role in all this? Because a lot of the conservatives have narrow conceptions of the federal police power, but there's also a lot of pressure within conservative political circles to regulate abortion. And so I think there's going to be a lot of interesting and unintended doctrinal consequences that will come out of this decision that has been simmering under the surface.
Well, I'll be very brief in my comments so we have time for Rob to talk about the Bruen case and also for your questions and discussion. One of my colleagues at Yale Law School, Bruce Ackerman, who is an intellectually honest liberal, a vanishing breed, said that Dobbs was a pro-democracy decision. And when you read the opinion, Alito really tries to emphasize that. He says that this is not an unenumerated right in the Constitution, and therefore we're returning it to the people. Another point he makes on a bipartisan basis is he quotes Ruth Bader Ginsburg as saying that this decision has not been successful in taking the abortion issue out of controversy. In fact, it's had the opposite effect. But nonetheless, the decision has been very controversial, and it may very well result in changing the result in the next election and allowing the Democrats to at least hold on to the Senate. So it's a highly important decision, and I agree with Ilya. It's going to be a controversial decision for many, many years. Rob, take it away with regard to Bruen.
Bruen will also be a controversial decision for many, many years. All right, so the Second Amendment recognizes a right to keep and bear arms. And in District of Columbia versus Heller, the Supreme Court held that that the Second Amendment right was not limited to members of an organized militia for discharging their official responsibilities, that it extended to the citizenry generally. But Heller was about the right to have arms in the home, the right to keep arms. The question that was assiduously avoided in Heller was, does the right extend beyond the home? And if you look at Heller, Heller says, well, we're not going to call into question laws regulating the carrying of concealed weapons or laws forbidding the possession of weapons in sensitive places, which suggests maybe that you can't outright ban the carrying of firearms beyond the home. You can ban them in certain narrow locations, and you can regulate the manner, but that's it. But that question had been left open. After Heller, the courts of appeals had engaged in what Richard Ray has called narrowing from below, basically a relentless war against the Supreme Court to narrow the decision as much as possible. And by the time Bruen came down, Heller barely stood for more than its facts, that states cannot have a general ban on the possession of handguns, but basically every other type of law was approved. Well, in Bruen, two individuals sued to get a full carry license. So New York bans the possession of a firearm without a license, and then it issues two kinds of licenses, resident licenses for the home and carry licenses for outside the home. And they had been issued restricted carry licenses for target shooting, and one of them had it for employment purposes. And they said, no, we want to have full carry licenses so we can generally carry a firearm for self-defense. And the court said no, and they sued in federal court, and the Second Circuit said no. Now, after years of ducking this issue, and the Supreme Court had been ducking this issue despite a circuit split, now it finally took the case, and the court held 6-3 that the Second Amendment does extend beyond the home, that states cannot enact a general ban on carrying firearms for individual self-defense. Now, the New York law required proper cause. Now, to have a full carry license, proper cause was not defined in the statute, but New York courts understood this as requiring some sort of special danger apart from the general community. So, by definition, the median person could not get a license to carry a gun. You needed some sort of special danger. Now, on the ground, how this got applied varied in every New York jurisdiction. Some just issued licenses and ignored the requirements. Others basically required police documented death threats. Now, the Supreme Court, now I think the decision here is significant for three reasons: what it held, what its methodology was, and what it didn't say. And so we have limited time, so I'm just going to do these very quickly, and we can talk more about it in the Q&A. So first, what Bruen held. Bruen held that there was some right to carry a weapon in public for individual self-defense. It did not say that there was a right to carry a concealed weapon or that you could have a concealed carry. The states had to issue concealed carry licenses on what is often called a shall issue basis. It just said that there is some right that extends beyond the home. So there's nothing in principle wrong with states that want to say, well, if you want to bear arms, do it openly, and we're going to strictly regulate the carrying of concealed weapons. Said nothing of the effect. Second, the court also said that the right was not unlimited or beyond regulation. So the court explicitly approved states regulating the manner of bearing arms and prohibiting the carrying of firearms in sensitive places. Now, what those sensitive places are and how far the states can go is presently being litigated. So New York passed a law basically banning guns on all private property unless invited, as well as a slew of other locations, including Times Square. New York City defined Times Square as basically half of the western side of Manhattan. And needless to say, they have been sued a second time. Second, I think this is interesting because of the methodology that it rejected. So lower courts, in narrowing Heller from below, had engaged in this sort of interest balancing test. It's saying, well, look, first we'll figure out if this conduct's within the right, and then if it's within the right, well, we'll let the state regulate it as long as they're acting for the public safety and didn't totally abrogate the right. And the effect of this is that it basically approved all gun control laws. This was the form that most circuits adopted. It's what's called intermediate scrutiny. It's supposed to be very strict and the kind of justification you would need to, say, approve a law that engages in sex discrimination, but that's not the way in the gun cases it worked on the ground. On the ground, courts were very deferential and said to legislatures, basically, if you have any rational basis for putting this law into effect, we're going to uphold it, although they couched it in the language of intermediate scrutiny. And the court said, no, this sort of balancing is out, and we're going to replace it with a text history and tradition test. And I think the text history, to look how it's applied, the court, I think, looked to what the general law was, both during and after the framing. And so when you see the court saying, well, look, most of the jurisdictions were this way, there were a few outlier jurisdictions, what the court was doing is looking to what was at one time called general law. And supposedly general law doesn't exist after a Supreme Court case called Erie versus Tompkins, but there are pockets where the general law exists, and here I think the court was looking at it. The court said that to sustain a law, there has to be some sort of historical analog, and there's going to be tremendous litigation on what that means and how close of an analog it has to be. So there are a lot of laws, like the carrying of guns on airplanes, that have no historical analog, as well as laws that are widely approved by both sides of the political aisle, like banning convicted felons from having guns. That was a regulation that started in the 1930s and crystallized more in the 1960s, but it was not a traditional 19th century regulation. So I think how this history test is going to be carried out in practice is questionable and is still questionable and problematic. And so I guess I'll leave it there.
That's good. Ilya, would you like to comment?
Yeah, two quick things. Robert was talking about how this doesn't affect other types of traditional regulations, and there's a concurrence by Roberts and Kavanaugh saying the same thing. It doesn't imperil most states' permitting regimes. Most states do not have what's called constitutional carry, meaning that as long as you're over 18 and not a felon and not mentally incapacitated, you can just carry. Permits are okay, which requires paying something, maybe a little bit of training or whatever. That doesn't imperil those. What this did overturn, though, is the half dozen what are called may issue states: California, Hawaii, Massachusetts, New Jersey, New York, and Maryland, where even after you've satisfied the objective criteria, a sheriff or police captain reviews whether you have a good enough reason to want to carry. And as Robert alluded, in New York at least, and generally in these half dozen states, unless you were retired law enforcement or a celebrity or had 17 explicitly detailed death threats against you in the last week, you weren't going to get it. So it throws out that kind of effective ban on carrying. Second, an unrelated point is the significance of who authored it, and that's Justice Thomas. Almost certainly, he's been on the bench 30 years now, that almost certainly his most significant opinion was Bruen. And even though this term, like terms past, Roberts and Kavanaugh were most often in the majority, this term 95% of the time, I think you can't really, it's not Roberts' court, he's not the man in the middle. Kavanaugh really hasn't put his mark on the court. It's really Thomas, who's the senior associate justice, which means he assigns the opinion when Roberts is not in full agreement. And that means that in Dobbs, for example, he was the one who got to assign it to Alito. So I think what we're seeing is the rise of the Thomas court.
Thank you very much. So 2 quick points. First, I want to recommend to all those of you who are interested in gun issues and related issues an excellent blog that Rob hosts called Standing His Ground, all one word, Standing His Ground, and very, very interesting work about these developments. I agree with Rob that the methodology with regard to the emphasis on history is a very important trend in the case. The court says it's difficult and nuanced to interpret history, but it's better to rely on history. It's more constraining of the judges than having judges make policy decisions about costs and benefits of legislation in an area in which they're not expert. And there's also a significant emphasis on history in Dobbs, and also to a certain extent in West Virginia versus EPA, that the agency had not done this, had not interpreted the law in that way previously. So I think one of the things that's a common theme in all 3 cases to pay attention to is the changing and more important role of history in a court which is very concerned about constraining judicial discretion. Okay, well with that, we have about 20 minutes for your questions and comments. Who would like to ask the first question? Sir. And then these 2 in the back. Why don't you state your name and then ask your question?
Sure. My name is Aiden Stretch. First of all, thank you for being with us. And I'll leave this to whichever one of you wants to answer it. But I'm interested to hear what your thoughts are on Justice Kavanaugh's concurrence in Dobbs. I think there are many on the left who characterize it as sort of a weak attempt to be humane while still striking down Roe v. Wade. But then there are others, and I'd probably consider myself among them, who see it sort of, as you put it, Mr. Shapiro, that Justice Kavanaugh is saying, I know I'm the 5th man, so to speak, and here is where I stand on future abortion cases, should they come before the court. And I'm interested to hear which side do you think has it right, or is there another explanation for that concurrence?
Well, his opinion, I mean, he does this frequently. He has these hand-wringing concurrences saying, I recognize the passion on the other side, and nevertheless, you have strong arguments. It was a good fight and a close fight, but here's the rule. And don't misunderstand. Here's what what it says and what it doesn't say. Did the same thing in Bruen. I think it's pretty clear that not just him. There's not going to be 5 votes. Or there is going to be 5 votes, rather, to uphold the right to travel if any state, criminalizes going to another state to get an abortion. I don't think that's going to hold up. Other things, it just depends. It's different areas of law. So you talk about congressional action. It depends, what is the authority of Congress? There's Commerce Clause issues. If you're just regulating abortion directly, is that a regulation of interstate commerce? Conversely, if you have Republican proposals to have fetal personhood, that wouldn't be done under the Commerce Clause. That would be done under Section 5 of the 14th Amendment, where Congress gets power to enforce civil rights. It's not really been litigated very much, open question where it would go. But those are kind of the things that are talked about a lot. As for kind of more extreme things that some in the left have expressed concern about, some genuinely, some I think disingenuously, it comes off of, and this goes beyond your question, but comes off of Justice Thomas's concurrence, where he expressed doubt about substantive due process. I share his methodological doubt. I'm a big privileges or immunities clause of the 14th Amendment kind of guy, which doesn't make difference in a lot of cases. Some might. But for practical purposes, you had 5 votes in Alito's opinion that says abortion is different from all these other things. For one thing, marriage cases, that deals more with equal protection than it does with due process. But anyway, that goes beyond your thing. But you really have to zero in on the particular regulation, whether it's state, whether it's federal, what the authority is. But we'll see what happens. States are currently still trying to pass legislation and figure out where exactly they want to go.
Rob, do you want to add anything, or shall we get more questions? Let's get the questions in. First, the gentleman in the back with the great T-shirt. Not that other people's shirts aren't great too, but he had a very good one.
Thanks. My question. My question, well, it's sort of 2 questions. The first question, how do you think the abortion case will change the way that privacy is seen or dealt with in the future? And the other question is, how do you think the EPA case will change the purview of other departments, and will it kind of cause a backlog of potential actions that are like waiting to pass Congress? And how do you think that will change the way that different departments kind of look at the way that they can act?
Want to go first?
Sure. Sorry, how will the abortion case do what? Sorry?
Change the way that people
Think about privacy, right. Well, I think privacy in that sense is different than the way we think about privacy for Fourth Amendment purposes in the criminal law. And I think it's different than the way we think about privacy in digital surveillance contexts. So I don't, people generally don't put abortion and surveillance and, cops searching things into the same bucket. Lawyers do that because the word privacy kind of has a salience in each of those, but I don't think this case will affect those other areas.
Yeah, with regard to the effect on other agencies, I think the honest answer is it remains to be seen. And it could be very, very broad. That's what concerns me, because I don't think the tests that the court has enunciated to date are at all constraining. And I think this is really ironic in a court that seems to be very concerned about judicial policy making. This is an open invitation that's being seized on by the lower courts to declare that almost anything they don't like, it violates the major questions doctrine. I don't think that's what the Supreme Court intended. I think Roberts went out of his way to say this was an extraordinary remedy. But if they don't want to discourage a lot of other actions by agencies, they're going to have to come up with some better limiting tests. And there was an excellent amicus brief by my former student and friend, Ricky Rivez, who is the former dean at NYU, showing that there were numerous EPA rules in the past that had political and economic consequences larger than the one in question. So I think that really shows how difficult a test is to define what is question is sufficiently major that it has to be answered by, has to be addressed by Congress. The next person in line was the one in the...
Rivez was just appointed the regulatory czar.
I know, and I'm circulating a letter endorsing his nomination. I wonder if you'd like to sign it.
Probably.
Fellow in the...
I don't know if that would help him, though.
Yeah, it would. Yeah, it would. Go ahead. Fellow in the green shirt.
Okay. Yeah, so one of the questions that's kind of obscure whenever I see people on the right in particular debating it is the non-delegation doctrine. You guys mentioned it. I always find it interesting how it seems that originalists talk a lot about it, but I haven't really seen what historical evidence they point to aside from previous court precedent as to it actually being a standard that can be meaningfully implemented. How can the court limit Congress in a way that is consistent with the historical record? Is there anything in the historical record that any of you think that originalists could point to?
Well, I'd like to address that. It's something I've thought about a lot. I don't think that the delegation doctrine has much promise to constrain the administrative state. I think there were a number of other remedies. The Administrative Procedure Act, I've recently written an article about how the court interpreting the Administrative Procedure Act very narrowly undermined Congress's intent. The Chadha case, getting rid of the legislative veto. From a historical standpoint, what I think is interesting is that we had courts in the colonies, including in Connecticut, that had been construing state or colonial constitutions for almost 150 years before the Constitution was adopted. And they were basically interpreting broad terms in the Constitution in a common law way. And why, when the judicial power is vested in the Supreme Court, which is the textual basis for the non-delegation doctrine, would we assume that that was intended to have anything different than what the colonial courts had been doing? So I think the historical evidence cuts in the opposite direction. And that's one of the reasons that I think the move toward historical evidence is so significant. And I think, going to Ilya's point, I'm also a big privileges and immunities as opposed to substantive due process guy. I think privileges and immunities is much more amenable to historical analysis, whereas substantive due process asks for the kind of interest balancing that Ilya and the court are rightly opposed to. Okay, other questions?
I
yeah,
want
please.
to say something on this. So I think, well, the point about the non-delegation doctrine is it's separation of powers, right? So Congress can't say, all right, we don't like doing our jobs, we'll just let the president do the job. We'll just let the tsars, whoever the president appoints, make the laws, and we'll just go campaign and have fun and stuff. Or the court says, or any court says, yeah, these decisions are too hard. I'll appoint the faculty of Yale Law School. They can make the decisions, right? These kinds of, there's something wrong with that. It's not just odd sounding, but improper in terms of the legitimacy of government. So that's where it's comes from. And it's hard to do historical analysis because the kinds of delegations that would be problematic really are only possible with the growth of the modern administrative state, kind of the proto-growth under Woodrow Wilson, and then more at the New Deal, and then more especially in the 60s and 70s. So it's not like you're going to get an example in the 1830s where somebody, Congress, delegates some broad thing somewhere, and the courts are struggling with whether that's proper or not. So that's the other thing I want to say is about hydraulic forces. There was a case called Gundy about 5-6 years ago involving whether there was an intelligible principle in delegating to the Attorney General to write certain rules about how to retroactively treat sex offenders. And it was a non-delegation doctrine challenge that the court ultimately rejected the challenge 5-3. This is after Scalia died. Alito joining the progressives, but only in the judgment, saying, yeah, I think there's some merit to non-delegation, but I don't want to take it up in this weird, bizarre, he actually said, criminal case. For the dissent, Gorsuch was just fire-breathing and fully joined by Thomas and Roberts, and saying, I like non-delegation, but you know what else? Sometimes when doctrines aren't used for a long time, other things evolve to take their place and do the same work. So substantive due process, because privileges or immunities was eviscerated 5 years after the Fourth Amendment was enacted in the slaughterhouse cases. A similar thing is happening here with major questions doing the work, not just similar work of non-delegation, but also of Chevron deference. If those of you who don't know, which congratulations, because that means you're still living what you should be doing in college rather than studying administrative law, is how much deference should judges give agencies when they're interpreting their operative statutes. And if you do a Control F search in the West Virginia case, you will not see the word Chevron, nor will you in the American Hospital Association versus Becerra case, very dry, boring technical case about Medicare reimbursement. That was supposed to be the court looks at Chevron and changes it and stuff, but no. That was a statutory interpretation case that went 9-0. This was a major questions doctrine. So as Gorsuch said in Gundy, this major questions thing is becoming a major doctrine. And we saw that in King versus Burwell, this statutory challenge to Obamacare now, 8 years ago, where the court did not just defer to the IRS drawing up these subsidy regulations, but said, no, that's too big an issue for an agency to look at. We're going to do it in the first instance ourselves. So that, non-delegation is very interesting, but it's quite literally at this point, I think, an academic point where the court goes out of its way to find other doctrines to do similar work.
So we have time for 2 more questions, maybe 3 if those of us on the panel restrain ourselves. So here you go. First here and then in the back. Yes.
Hi, how's it going? I'm Braxton Buff. I want to once again thank all y'all for being here. My question is about the Dobbs leak. Something that's always reaffirmed my faith in the American system is the Supreme Court, how robust it is, and I'm curious as to what all of you think about the long-term effects of the leak. Has it completely decimated trust in the court, or is it something that the court can bounce back from?
I mean, I think from a public relations standpoint, I'm not sure that it matters either way. I think the public relations often supervenes on whether citizens like the decisions or don't like the decisions of the court, and I don't think most of the citizenry is terribly interested in how the sausage gets made. So from that end, I don't think the leak has much effect. I think the leak will have a terrible effect in terms of the internal deliberations of the court. It may make some of the justices more restrained when talking to each other. It may also interfere with how the justices interact with their clerks and other court employees. Now, something like this isn't totally out of the minds. When Brown versus Board was circulated, the justices actually kept the decision among themselves, and except for the chief's clerks, I think the clerks were generally not authorized to read the drafts. And so it might be the case that very, very high-profile cases are kept a little closer than this one was, and maybe this one should have been, in hindsight, kept closer than it was. So I think it may have a profound impact on the internal workings of the court. I think one of the good things is that the decision did not materially change. And that's good because you don't want to see this sort of leak successfully intimidating the justices. So I don't think it'll matter much in terms of the public. I do think it'll matter quite a bit in terms of the internal procedures.
Here. Just while they're passing the microphone, one of the things I learned when I was in government, when you have leaks, you have to ask yourself who benefits. So think about who had the motivation to wave the court off. Go ahead.
Hi, thank you guys for coming. My name's Johnny Dedyo. But my question is, so when Dobbs was originally leaked, I remember there was a major uproar about the fact that Kavanaugh had said in his confirmation hearing that Roe v. Wade was settled as precedent. What's your opinion on the fact that he went back on that statement, and do you think it's going to have an effect on...
He chose his words very carefully here. And if you look at what nominees from both parties do, they do it. And the senators, for whatever reason, never follow up. So he says, look, this was a decision of the court, and I respect precedent. He never committed to not overturning it, and he never said that he thought the original decision was right. And when you look at Justice Jackson, during her confirmation hearing, she said Heller was a decision of the court. And
it's due all the respect that all court decisions are due.
Right. She never said that she believed that as a de novo matter, there is an individual right to bear arms. So I think, the part of the confirmation hearings is just symptomatic of the fact that the court has a little bit too much political power in our system at the moment, and so people are always trying to gauge where they are as a proxy for what policies will come into effect. But Justice Kavanaugh never went back on his word. He framed it as deliberately as everyone else does.
Now, if Senator Collins thinks that she was hoodwinked, then then she wasn't parsing what he was telling her very closely.
Well, and just to add to that, it would be illegitimate for justices to make a commitment as to how they would rule in a future case. So I think to some degree, this kind of dancing that both sides do is necessary and appropriate, because they can't say, no, I would vote to overturn Roe, or I wouldn't. And I think people who want to embarrass them often try to put an interpretation on their words that it really doesn't bear. Time for one more question. Woman way in the back. I'm sorry here, but you there.
I am interested in, with regard to Bruen and Heller and the Second Amendment, but also just all the amendments that originally only applied to the federal government and then were selectively incorporated to apply to the states. When we're doing like an originalist interpretation of these amendments, to what time period should we look?
I think that's an open question at the moment. Bruen actually doesn't give us a very good answer on this. So the Second Amendment recognized a pre-existing right at law to keep and bear arms, and I think there are 2 and maybe 3 time periods you could look at. One is the scope of the law in 1791 when it was originally drafted. Second is the scope of the right in 1868 when the 14th Amendment was adopted. And the third is what the scope of the general law is today. And Bruen gives you a little bit of everything on this. So although the Second Amendment originally applied only to the federal government, the right to bear arms as such was generally applied to the state governments through their state constitutions. And these weren't viewed as independent state guarantees so much as a reflection of what the general right was. And there was a lot of case law on the right to bear arms in the 19th century. If you want to know today why a lot of states prohibit people or restrict people from carrying concealed weapons, but generally leave openly carried weapons unregulated, it's because it was the prevailing view during the 19th century that the right to bear arms was the right to bear them openly, and that states could regulate the carrying of concealed weapons. And that law is still with us through statutory law today. If you look at what Bruen says, though, Bruen looks a little bit towards 1791 and then looks at the history with the 14th Amendment. And then in terms of its way it's operationalized, it says, well, we're not calling into question modern shall-issue permitting schemes. Well, if you look at the cases in the 19th century that involved licensing, it usually applied to free blacks, and it was usually under the theory that the right to bear arms did not fully apply to them. The idea that the state could condition the right to bear arms on a license, which was only issued after government mandating, totally foreign to how the 19th century played out, and looks very much like the modern interpretation of the right to bear arms. And I think you will see this also with this assault weapons and machine guns, that the 19th century position was that the right to bear arms was the right to have military arms for military-related purposes in addition to self-defense. But given that there's such an overwhelming consensus against individual possession of machine guns, I'm willing to bet that the Second Amendment will be interpreted differently. So anyway, I think this is very much an open question. You'll note that Justice Barrett's concurrence says I'm leaving that question open, and we'll see where the court takes it. But when you're engaged in originalism, this is a good debate to have.
So jurisprudentially, it's an open question. I think academically, at least this is my view, I think you have to do originalism at the right time. And this is where some of the mischief in overturning or eviscerating privileges or immunities and kind of warping the 14th Amendment plays a big role, because the framers had, the enactors of the 14th Amendment, they had the linguistic capacity to say, well, the first 8 amendments now apply to the states. They could have said that. They didn't. They said due process, equal protection, privileges or immunities. And as another one of Don's colleagues, Akil Amar, likes to say, the 14th Amendment protects both more and less than the Bill of Rights. And what the right to bear arms in 1868 meant was slightly different than it was in 1791. 1868 is about political minorities who were being oppressed of various kinds, both freed slaves and Southern sympathizers in the North, and Chinese workers in the West, all these sorts of things. And at the founding, it was tyranny and all these other things. And since if we're applying the 14th Amendment, then we should be doing what it meant when it was, what did those terms mean when it was enacted? But that's Josh Blackman and I have a law review article about this when McDonald versus Chicago was pending in 2010, called "Keeping Pandora's Box Sealed," that talks about all of that. But jurisprudentially, it's an open question, as Robert said.
Well, you see why I said these are two of the leading legal theorists in the country, and thank you both for your sharing your ideas with us tonight.
Yeah.
Thank you very much.